Namaskar. A very good morning to all the nodal officers as well as judicial officers, Punjab, Haryana, and UT. I also welcome the technical staff deputed across Punjab, Haryana, and UT Chandigarh who have also gathered here in this webinar. Today, the topic for the webinar is video conferencing rules. This webinar would be taken up by me. I am Harshali Chowdhary, faculty member cum additional district and sessions judge belonging to Haryana Superior Judicial Services. I am also a master trainer with E-Committee, Honorable Punjab and Haryana High Court. I am also a certified ethical hacker with a keen passion towards technology and law. I also had the opportunity to be nodal officer at my previous place of posting. As I begin with my session, I would like to inform that live chat box on YouTube is open and participants may post their queries, thoughts pertaining to the topic therein. If time permits, the same may be answered to the best of my ability. Now, talking briefly as to how video conferencing as we have today came into picture, I would like to draw the kind attention to a letter dated 22nd of December 2016, where Honorable Punjab and Haryana High Court was pleased to inform the judicial officers that the software-based video conferencing facility vcphhc.gov.in had started functioning in all networks, that is FAN, Pawan, NICNet, VPN, and public network, that is broadband and cellular. All the judicial officers were requested, along with the system officers and system assistants in the sessions division, for maximum usage of the same. Further, it had also been desired by the authorities that all kind of evidences, remand work, VC with doctors, VC with other institutions, preferably be carried out through VC mode only, and proper record in soft form regarding number of VCs conducted be maintained by system officer concerned. Maximum work pertaining to video conferencing be done through software video conferencing only. Thereafter, in the year 2017, wide letter dated 25th of February 2017, issued again by Honorable Punjab and Haryana High Court, Honorable E-Committee had been pleased to suggest the judicial officers across Punjab, Haryana and UT Chandigarh to go through the guidelines laid down in the case of State of Maharashtra versus Dr. Praful B. Desai and Kalyan Chandra Sarkar versus Rajesh Ranjan alias Pappu Yadav, wherein the appearance of the hardcore criminals are required to be done. Now, in the year 2018, video conferencing guidelines for the conduct of court proceedings between courts and remote sites and the VC facilities set up at other places in the state of Punjab, Haryana and UT Chandigarh were framed by Honorable Punjab and Haryana High Court, and they were received wide letter dated 7th of July 2018. Now, during COVID-19 pandemic, directions by Honorable Supreme Court in reference guidelines for court functioning through video conferencing, suo motu writ Civil number 5 of 2020, dated 6th of April 2020, Honorable Supreme Court was pleased to pass the direction that until appropriate rules are framed by the High Court, video conferencing shall be mainly employed for hearing arguments, whether at the trial stage or at the appellate stage. In no case shall evidence be recorded without the mutual consent of both the parties by video conferencing. If it is necessary to record evidence in a courtroom, the presiding officer shall ensure that appropriate distance is maintained between two individuals in the court. Now, in view of the said directions, Honorable Computer Committee of Honorable Punjab and Haryana High Court, via order dated 8th of April 2020, had been pleased to recommend the following interim measures with regard to use of video conferencing facility as email received on 17th of April 2020. The committee recommended that secure online applications for the purpose of video conferencing, that is video, WebEx, live sites, etc., can be used at the first instance, and only if these applications are not working at a particular time or wherever there is less bandwidth at the lawyer's end or there is no compatibility for the video conferencing software chosen with the lawyer's device, etc., recourse be taken up for conducting the VC through other software applications or video calling facilities such as WhatsApp, Google, Duo, etc. In unforeseen circumstances, proceedings be conducted through voice call conference or teleconference facility after establishing the identity of the lawyer litigant to that effect. It was further requested to ensure that the contact number of the officials deputed for conducting the video conferencing be displayed in the district court website of the respective district, and the same be also shared with lawyers, litigants concerned participating through VC. Now, rules on video conferencing formulated from Honorable Supreme Court of India were received by us by the judicial officer by letter dated 21st of May 2020. Thereafter, Honorable Supreme Court in its order dated 26th of October 2020 observed and also directed that we propose to substitute subpara 7 of paragraph 6 with the following: the video conferencing in every high court and within the jurisdiction of every high court shall be conducted according to the rules for that purpose framed by the high court. The rules will govern video conferencing in the high court and in the district courts and shall cover the appellate proceedings as well as trials. We are given to understand that several high courts have framed their rules already. Those high courts who have not framed such rules shall do so, having regard to the circumstances prevailing in the state. Till such rules are framed, the High Court may adopt the model conferencing rules provided by E-Committee, Supreme Court of India, to all Chief Justices of the High Court. Accordingly, our own Honorable High Court adopted these model video conferencing rules. At present, we have video conferencing rules which were incorporated in Part H, Chapter 1 of the Rules and Orders of Punjab and Haryana High Court, Volume 5. Now, before I proceed with the rules and explain the nitty-gritties of the rules, we all know that we have been using the video conferencing since its inception. But for the purpose of understanding these rules, I would request the participants to have an open mindset. Let's forget that we already know as to how to conduct the video conferencing. Let's forget the problems that we are facing right now with regard to the video conferencing. Let's embrace these new rules. Let's learn these new rules by unlearning as to what we already know, so that now we will be able to use, to implement, to execute the rules in accordance with the procedure laid down for the purpose of video conferencing. So now perusal of the said rules reveals that it consists of 5 chapters, 19 rules with 2 schedules. Under Rule 1, Chapter 1, which is also known as preliminary, it is evident that the application of the rules would be on such courts of proceedings or classes of courts or proceedings and on from such date as the Honorable High Court may notify, and the rules shall come into operation as notified. Here I would like to add that Honorable High Court is yet to classify such courts or such proceedings on which the said rules are going to be applied, and also the rules are yet to be notified by Honorable Punjab and Haryana High Court, although they have already been incorporated in Punjab and Haryana High Court rules and orders. Now, Rule 2 gives out the definition of certain words being used, and the same shall be explained during the presentation as and when they are used. Now, during my tenure as a presiding officer, I could not recall a single working day when I had not physically examined witness. So before I delve further with all the technical jargons thrown here and there, I would like to put the esteemed audience at ease that there is nothing new in the procedure so stated in the rules, except that now the witness would be examined through a software sitting remotely by following all the procedure and protocol as required to be followed by the concerned person involved in the video conferencing. Now the software, the video software that we are talking about is the video conferencing software. It may be video, it may be WebEx, it may be Jitsi, it may be Zoom, it may be any software video conferencing application. Now the word video conferencing has not been defined anywhere in the rules, but in common parlance, it is a live video based meeting between two or more people in different location. It is a platform to meet people and collaborate face to face from long distance by transmitting audio, video and text through internet. It saves time, it is cost effective, and it reduces hassles associated with traveling. How these video conferencing rules aid the already existing rules for the purpose of examination of the witness or for the purpose of conducting the proceedings in the court, it can be seen with the reference of Rule 3, which is General Principles Governing Video Conferencing. Now, according to Rule 3.1, video conferencing may be used by all stages of judicial proceedings and the proceedings by the court. 3.2 speaks that the proceedings conducted by the court by way of video conferencing shall be judicial proceedings, and all the courtesies and protocols applicable to the physical court shall apply to such virtual proceedings. Rule 3.3 speaks that all the relevant statutory provisions applicable shall apply to proceedings conducted by video conferencing, subjecting to maintaining independence, impartiality, and credibility of the judicial proceeding, and subject to such directions as the High Court may issue. Courts may adopt such technological advances as may become available from time to time. Rule 3.5 says that the rules as applicable to the court shall apply to a commissioner appointed by the court to record evidence and to an inquiry officer conducting an inquiry. Now, the definition of the court, the word court that we have been using, it's given under Rule 2.4, which speaks that it includes physical court and virtual court or tribunal. Now, with that note, let me take you all to a court scenario to see the practical application of how these rules can be implemented. Now, for that, we all have to understand the entire procedure step by step. Now, what would be the first step? The first step would involve the request for video conferencing. Any party to proceeding or witness, save and except where the proceedings are initiated at the instance of the court, may move the request for video conferencing. The next question is that how such request is to be made. The answer to that query would be that the party or witness seeking a video conferencing proceedings shall do so by making a request in the form prescribed in Schedule 2. If I may share the form as appended in Schedule 2, it would look something like this. Now, this is the form. It is a form contained in Schedule 2. It is a request form for video conferencing. The party who wants to have the video conferencing, who wants to get the witness examined through video conferencing, would require to fill the said form by filling the particulars so given, as we can all see. This form is available with the video conferencing rules in Schedule 2. Now, the application is required for appearance, evidence, and submission by video conferencing in view of Rule 6.1. Now, the second step would be that after receiving the said application, notice to the application is required to be given to the other parties or party to the proceeding, which is evident from the language of Rule 6.2, except where it is not possible or inappropriate in appropriate cases, for example, in cases such as urgent application. Step 3 would be that after seeking the reply to the application and upon hearing all the concerned persons during consideration, the court will pass the appropriate order, keeping into mind that application is not filed with an intention to impede a fair trial or delay the proceedings as evident from Rule 6.3. Now, in case the court allows the application, that would take us to step 4. In such scenario, the court may also fix the schedule for convening the video conferencing, that is date, time, place or venue of the concerned remote point in view of Rule 6.4. Also, according to Rule 5.7, where the witness to be examined through video conferencing requires, or if it is otherwise expedient to do so, the court shall give sufficient notice in advance, setting out the schedule of video conferencing, and in appropriate cases may transmit non-editable scanned copies of all or any part of the record of the proceedings to the official email account of the coordinator of the concerned remote point designated in accordance with Rule 5.3. We have at the time of registration received many queries with regard to the VC facility not available in the jail, or it is preoccupied, or the concerned remote point is busy, or jail officials do not pick up the phone. So with the stations like Ludhiana or Gurugram, it can be very tedious and exhausting to conduct the video conferencing. So in that scenario, what is required to be done, or what can be done to resolve this situation? Now, we know that at the time of passing the order, the court is required to give a schedule with regard to the time, place, venue of conducting the video conferencing. But now, taking a cue from special provision added in video conferencing rules by Honorable Odisha High Court, it says that court, while allowing the application among other things, also gives the witness a precise time for recording of his or her evidence through video conferencing. So in case each court prepares its schedule beforehand for VC purpose and intimate to the court coordinator and the remote coordinator the issue may be resolved. Now I have been using the word coordinator, remote point. These words I shall be dealing in detail with the definition and other ancillary definitions in a while. Now, after the passing of the order, or at the time of the passing of the order, as we have also seen in the form that there was a column for the cost. Now, the question is that what kind of cost can be imposed, what kind of cost can be asked by the parties to pay. So now, while allowing the application, cost if directed to be paid shall be deposited within the prescribed time for commencing from the date on which the order convening proceeding to video conferencing is received as per rule 6.6. Now here the question is that what factors are to be taken into consideration while assessing the cost? Who is to pay the cost? Can the cost be waived too by the court? So far, the cost of video conferencing are concerned, Rule 13 gives out the detailed provisions as to what factors are to be taken into consideration while determining the cost in criminal cases as well as in civil case, and who is to pay the said cost respectively. The cost may include expenses to witness and complainant. Discretion has also been given to the court to waive the cost as warranted in the given situation. Now, apart from moving an application, what other formalities are required to be completed by the parties requesting for video conferencing? Now here I would like to draw the attention of the esteemed audience towards Rule 12.4 and 12.5 respectively, that where parties requesting for recording statements to the person to be examined by video conferencing, they shall confirm to the court the location of the person, the willingness of such person to be examined through video conferencing, and the availability of the technical facilities for video conferencing at the agreed upon time and place. Similarly, in criminal cases where the accused person is to be examined is a prosecution witness or a court witness or a defense witness, the counsel for the prosecution or the defense counsel, as the case may be, shall confirm to the court the location of the person, willingness to be examined by video conferencing, and the time, place, and technical facility for such video conferencing. Now, in case the person to be examined is an accused, then the prosecution will confirm the location of the accused at the remote point in view of Rule 12.6. Now, the next step involved with regard to the video conferencing process is the service of summons at the end of the court. Now, what is required for the purpose of service of summons to be sent to the person is given under Rule 7. Rule 7 states that summons issued to the witness which is to be examined through video conferencing shall mention the date, time, and venue of the concerned remote point. The court shall also direct that the witness is to attend in person along with proof of identity or an affidavit to that effect. The existing rules with regard to the service of summons and consequences for non-attendance as provided in the procedural law shall apply with respect to the service of summons proceedings conducted by video conferencing. It would be worthwhile to mention that if a person is examined with reference to a particular document, then summons to witness must accompany by a duly certified copy of the document. So, for example, a medical doctor is required to be examined through video conferencing. The summon should have all the medical documents which are required to be proved by the said doctor in the shape of its certified photocopy. This is the language of Rule 8.5. Now, here I would like to introduce 5 terms to our esteemed audience. The first term is the court point. Court point is defined under Rule 2.5, means the courtroom or one or more places where the court physically convened, or the place where commissioner is as defined in Rule 2.2, or an inquiry officer holds proceedings pursuant to the direction of that court. Another term is court user. Court user is defined under Rule 2.6. It means a user participating in court proceeding through video conferencing at a court point. Remote point under Rule 2.10 is a place where any person or persons are required to be present or appear through the video link. Remote user is defined under Rule 2.11, means a user participating in court proceedings through video conferencing at a remote point. We will be using coordinator terminology coordinator a lot. So coordinator is defined under Rule 2.3. It means a person nominated as coordinator under Rule 5.1, which speaks with regard to the coordinator both at the court point and at the remote point from which any required person is to be examined or heard. Now, what is required person? Required person is defined under Rule 2.12, which includes the person who is to be examined or the person in whose presence certain proceedings are to be conducted or recorded, or an advocate and party in person who intends to examine the witness, or any person who is required to make submission before the court, or any other person who is permitted by the court to appear through video conferencing. Now, here is the question that who is the coordinator at the court point as well as the remote point? Now, under Rule 5.2, it states that in civil and criminal courts falling within the purview of the district judiciary, persons nominated by the High Court or by the concerned district judge shall perform the function of coordinator at the court point as well as the remote point as provided in Rule 5.3. In case the system officer or system assistant is appointed as the coordinator at the court point by the learned district judge, he shall accordingly act as the same. Rule 5.3 gives out a table with regard to the coordinator at the remote point and what are the remote points. I will show you the set table which is available under Rule 5.3. If we can see this table under Rule 5.3, as many as 10 locations were recognized as a remote point, and the remote point coordinator are also explained therein. For example, for overseas, as a remote point, the remote point coordinator shall be an official of an Indian consulate or the relevant Indian embassy or the relevant High Commission of India. For jail or person, the concerned jail superintendent or officer in charge of the prison. For hospitals administered by the central government, the state government or the local bodies, medical superintendent or an official authorized by them or the person in charge of the said hospital. In case of forensic science lab, the administrative officer in charge or their nominee. So these are the remote points and remote point coordinator for the purpose of video conferencing. Now we have also received a question that under section 13B cases, if one of the parties is in overseas country and wants to make the statement, that is second motion statement, is it mandatory to conduct video conferencing through embassy officials, or we can directly provide the link to the party? Now, according to rule 5.3, since official embassy is the remote point for the overseas, and an official of an Indian consulate or the relevant Indian embassy or the relevant High Commission of India is the remote point coordinator, it is mandatory to conduct the VC through embassy officials only. The link cannot be provided to the party separately. Another question is that whether or can the presence of the remote coordinator be dispensed with at any point of time? Now, according to rule 5.1, the coordinator may be required at the remote point only when the person or accused of an offense is to be examined. Now, for example, if the arguments are to be arrested, in that scenario, remote point coordinator is not necessarily be present at the remote point during the submission of the oral arguments. Now, there are at times it so happens that for some of the witnesses, we require translators or expert or interpreters under special circumstances at the time of the recording evidence. So now the question here is that who shall arrange for the translator, expert, interpreter under special circumstances if required in case of the person to be examined is not conversant with the official language of the court or in sign languages, in case the person to be examined is impaired in speech or in hearing, or an interpreter or a special educator as the case may be, in case a person to be examined is differently abled either permanently or temporary. And how about the payment of cost? Now, according to rule 5.9, whenever required, the court shall order the coordinator at the remote point or at the court point to provide the necessary assistance. As per Rule 13, the cost shall be included for the payment of such persons in the total cost of video conferencing. Another question is that is remote point coordinator also entitled to any honorarium? Now, as per rule 12.9, the coordinator at the remote point shall be paid such amount as honorarium as may be directed by the court in consultation with the parties. After the notice has been served, or where the notice is in the process and the due date is to approach for the purpose of the video conferencing, let's go to step 7, that till the time the notice is served upon the witness and the date is approached for the examination of the said witness as per the schedule referred above, certain preparatory arrangements are required to be looked into for the purpose of conducting the video conferencing at court point as well as remote point. Now, taking into the technical aspects into consideration, following equipment are recommended for conducting the proceeding through video conferencing. For example, we require desktop, laptop, mobile devices with internet connectivity, printer, licensed antivirus protection for desktop and laptop, devices ensuring uninterrupted power supply, camera, mic and speakers, display unit and document visualizer, adequate sitting arrangement ensuring privacy, adequate lighting, availability of quiet and secure space, hardware for storage of video and audio, bandwidth and connectivity for the court user, remote point user, and VC application. Now, we have also received number of issues with regard to the bandwidth and connectivity. Now, we have to understand that for the purpose of video conferencing, there are 3 kinds of bandwidths and connectivity. They are required for the video conferencing vis-a-vis at court point, at remote point and for the video conferencing software. Now, this is for the system officers and the system assistants, that bandwidth and connectivity is not in your control. At the code point, there may be a good bandwidth or connectivity, but it has to be checked that what is the bandwidth available with the remote point. So for example, during the video conferencing, the video quality is poor or the audio quality is poor or the connection is being disconnected time and again. So if you are providing the requisite or more bandwidth, or if your internet connection is good enough for conducting of the video conferencing, then you have to be assured that nothing is wrong at your end, and there can be a problem at the end of the remote point or a remote point for the purpose of interconnectivity and the bandwidth. Another bandwidth that is required to be understood is of the video conferencing software application bandwidth. Now, if you are using Zoom, it requires its own bandwidth only due to the bandwidth that these software applications are popular. So where there is a data exchange through these software applications, for example, in Zoom, the files are compressed to the extent that it does not consume a lot of bandwidth and it telecasts so that the streaming is not affected. Even in YouTube, when we upload our videos, the uploaded video would not be immediately available, but what YouTube does is that it compresses the file. Now, for the purpose of conducting the video conferencing, it is suggested that Wi-Fi connection be not used for VC because it will be shared across the organization. Now, VC requires one strong connection, and that is why it is recommended to connect the video conferencing through LAN, that is local area network. Also, avoid connecting the video conferencing through mobile phones. Now, why I am saying that it is to be avoided? Because as we know that lots of mobile applications are running in the background. So when we connect through mobile on any of the VC software, the connection becomes poor. Even on the laptop or desktop connectivity, at the time of connecting, it is to be ensured that all the internet browser or the applications are closed. So even while on VC, do not connect on your WhatsApp as it will share your bandwidth. Now, what is the recommended network for seamless streaming? It would require, or it is recommended, that internet connectivity of minimum 1 Mbps for upload and 2 Mbps for download should be there. Higher bandwidth, that is 2 Mbps upload and 4 Mbps or more for download, will get better quality. Broadband 3G or 4G can also be used. Also, now the coordinator at the code point shall ensure that the video conferencing is conducted only through a designated video conferencing software. However, in the event of a technical glitch during a given proceeding, the concerned court may, for reasons to be recorded, permit the use of the software other than the designated video conferencing software for video conferencing in that particular proceeding as per Rule 12.2. So we have also received many queries that the license had expired of video. We were earlier given video, and there is a connectivity issue with regard to the video, and we do not have any good software applications which are compatible with the other video conferencing applications. So for that, again, I would like to draw your attention to the email dated 17th of April 2020, wherein Honorable E Committee of Punjab and Haryana had allowed the courts to use any, I would like to emphasize on the word any secure software application for video conferencing. liberty is also given to the extent that in unforeseen circumstances, proceedings be conducted through video call conferencing or teleconferencing facility after establishing the identity of the lawyer and all the litigants to that effect. So if video is not working, then accordance with the instructions so received by the nodal officer as well as by the learned district judge, any other online secure software application may be used for the purpose of video conferencing. Now, the word here I'm using is designated software. The definition of designated software is given under Rule 2.7, means the software provided by the High Court from time to time to conduct the video conferencing. Now, the next question or next issue is that how to deal with a situation when the required person is at one of the remote point mentioned in Rule 5 in Subrule 5.3 and video conferencing facilities are not available at any of these places. How to deal with the situation when the required person is at one of the remote points mentioned in Subrule 5.3 and video conferencing facilities are not available at any of these places. Now, in such scenario, the concerned court will formally request the district judge in whose jurisdiction the remote point is situated to appoint a coordinator for and to provide video conferencing facility from proximate and court premises, and this is given under Rule 5.4. Another question is that what procedure is to be adopted where required person is not capable of reaching the court point or the remote point due to any reason. Now, according to Rule 8.15, where a required person is not capable of reaching the court point or the remote point due to sickness or physical infirmity, or presence of the required person cannot be secured without undue delay or expense, the court may authorize the conduct of video conferencing from the place at which such person is located. In such circumstances, the court may direct the use of portable video conferencing system. Authority in this behalf may be given to the concerned coordinator and or any person deemed fit by the court. Now, where such situation is there that another remote point is required to be established, then who shall ensure the compliance of all the technical requirements at remote point for the purpose of video conferencing? Now, according to Rule 10.2, it speaks that although where the proceedings are carried from any of the report points as given under Subrule 5.3.1 to Subrule 5.3.9, the coordinator at such remote point shall ensure compliance of all technical requirements. But if the proceedings are conducted from the remote point falling in the situation contemplated under Rule 5.3.10, for example, an advocate office, the coordinator at the court point shall ensure compliance of all the technical requirements for conducting video conferencing at both the court point and the remote point. Now, Rule 10.3 speaks that coordinator at the court point shall be in contact with the concerned advocate or the required person and guide them in regard to the fulfillment of technical and other requirements for executing a successful hearing through video conferencing. Any problems faced by the remote users shall be resolved by the court point coordinator. The court point coordinator shall share the link of the video conferencing hearing with such remote users. Now, coming to the administrative aspects of the preparatory arrangements, At the foremost, before the scheduled video conferencing date, the coordinator at the court point shall ensure that the coordinator at the remote point receives certified copy, printout, or soft copy of the non-editable scanned copy of all or any part of the record of the proceedings which may be required for recording statement or evidence or for reference. However, these shall be permitted to be used by the required person only with the permission of the court as laid down under Rule 5.8. The coordinator at the court point shall ensure that any document or audio or video file emailed by the remote user are duly received at the court point as required under Rule 10.4. Rule 14.3 speaks that it is the court point coordinator who shall send the link, meeting ID, room detail via the email ID or mobile number furnished by the advocate as defined under Rule 2I or required person or other participant who are permitted to be virtually present by the court. Now, what is live link? Live link is defined under Rule 2.9 as means and includes a live television link, audio, video, electronic means or other arrangements whereby a witness, a required person or any other person is permitted to remain present by physically absent from the courtroom is nevertheless virtually present in the courtroom by remote communication using technology to give evidence and be cross-examined. Here I would like to take a pause and consider a practical situation which we have also received queries about, that at times the VC software that is being used at our end is not compatible with the VC software being used at the remote point. In that case, I would like to point out that it is the duty of the court point coordinator to send the link to the remote point coordinator of the software which the court point coordinator intends to use for the purpose of video conferencing. So for example, the court point coordinator intends to use WebEx for the purpose of conducting the video conferencing. It has to be ensured that at the remote point, WebEx only is being used for the same purpose so that the live link which the court coordinator is going to send to the remote point coordinator, it could be connected. So if we are at the court point using Zoom and at remote point they are insisting upon Microsoft Office, then of course any live link would not be working. So since it is the duty of the court point coordinator to send the live link, it is the duty of the court point coordinator only that he has to ensure that at the court point and at the remote point, the software being used for video conferencing are one and the same. Now let's see what happens in the proceeding before the court on the day of video conferencing. Now at the foremost, according to Rule 8.2, the persons being examined will ordinarily be examined during the working hours of the concerned court or at such time as the court may deem fit. As per Rule 12.7, however, the court may pass suitable direction concerning the timing and schedule of video conferencing as the circumstances may warrant. All advocates or required persons scheduled to appear in a particular proceeding at a remote point designated for video conferencing at least 30 minutes before the scheduled time, and this is the language of Rule 5.6.1. And now I share with you an instance which happened today, that before just connecting online and coming online on YouTube and starting with my presentation, just 5 minutes prior to that, the software that I am using for this broadcast, it got crashed. It got the software got it automatically closed, and it was just 5 minutes remaining with me to connect with all the esteemed audience. So I immediately called the technical assistants and asked him to connect it again and see if any software, any download is required to be done for the smooth video conferencing. So it so happens at times that at the nick of the time, the technical there would be a technical glitch, or it will not work, because it is a technology. It's not in the human, it's not under the human control. So that is why it is a duty of the remote point coordinator and the code point coordinator to check that whether all the settings in the video conferencing software that was being used are correct, if the connectivity is proper, if the bandwidth is proper, if all the required persons or the witnesses are already present at the remote point, if the remote point coordinator has already received the documents as referred above. So just 30 minutes prior to starting of the video conferencing, it will if all these steps are taken, a lot of disturbance that happened, or the technical glitches that happened during the video conferencing, it can be avoided. Now, all advocates, required persons, and the party in person or any other person permitted by the court to remain physically or virtually present, referred to as participant, shall abide by the requirements set out in Schedule 1 as given under Rule 14.1. Now, this fact has to be understood that even though the evidence is being recorded through video conferencing or online application, or the arguments are being advanced through video conferencing, but the protocols that are to be followed at the time of the physical recording of the evidence would remain same, even if the video conferencing is being conducted for certain proceedings. What are those protocols? These protocols are given under Schedule 1 of the video conferencing rules. Some of the protocols which I believe should be emphasized upon are that all participants shall wear sober attire consistent with the dignity of the proceedings. Advocates shall be appropriately dressed in professional attire prescribed under the Advocate Act. Police officials shall appear in the uniform prescribed for police officials under the relevant statute or orders. The attire for judicial officers and the court staff will be as specified in the relevant rules prescribed in that behalf by the High Court. The decision of the presiding judge or officer as to the dress code will be final. Proceedings shall be conducted at appointed date and time. Punctuality shall be scrupulously observed. The case will be called out and appearance shall be recorded on the direction of the court. Every participant shall adhere to the courtesies and protocol that are followed in the physical court. Judges will be addressed as Madam or Sir or Your Honor. Officers will be addressed by their designation, such as bench officer or court master. Advocates will be addressed as learned counsel or senior counsel. Advocates, required persons, parties in person, and other participants shall keep their microphone muted till such time as they are called upon to make submission. Remote users shall ensure that the devices are free from malware. Remote users and the coordinator at the remote point shall ensure that the remote point is situated in a quiet location, is properly secured, and has sufficient internet coverage. Any unwarranted disturbance caused during video conferencing may, if the presiding judge so directs, render the proceedings non-est. All proceedings cell phones shall remain switched off or in the airplane mode during the proceedings. All participants should endeavor to look into camera, remain attentive, and not engage in any other activity during the course of proceeding. Now, the coordinator at the court point shall also conduct trial video conferencing preferably 30 minutes prior to scheduled video conferencing, in order to secure all the technical system are in working condition at both the court time and remote time as per Rule 10.5. As per Rule 14.2, before the commencement of the video conferencing, all the participants shall have their presence recorded. However, in case a participant is desirous that their face and name be masked, information to the effect shall be furnished to the court point coordinator prior to the commencement of the proceeding. In accordance with Rule 8.10, the court may, at the request of the person to be examined or in its own motion, take into account the best interest of the person to be examined, direct appropriate measures to protect the privacy of the person examined, bearing in mind aspects such as age, gender, physical condition, and recognized customs and practices. Now, any person being examined, including a witness, shall, before being examined through video conferencing, produce and file proof of identity by submitting the identity document issued or duly recognized by the Government of India, state government, union territory, or in the absence of such document, an affidavit attested by any of the authorities in reference to Section 139 CPC or Section 297 as the case may be. The affidavit will inter alia state that the person who is shown to be the party to the proceeding or as a witness is the same person who is to depose at the virtual hearing. A copy of the proof of identity or affidavit, as the case may be, will be made available to the opposite party according to Rule 8.1. Similar requirement is also there under Rule 3.7 vis-a-vis a required person. Now, in a physical court, when we start with the examination of the witness, what do? At the foremost, we call the case, the parties appear before us along with the witness and the advocates. Then we establish the identification of the witness by looking into the identity card of the said witness or the person or the required person, and then we begin with the evidence. In serious cases or where the identity of the witness is required to be masked, or if the privacy of the witness is required to be protected, we make sure that the identity is not disclosed in the deposition. So similar requirements, so far the video conferencing, so far the proceedings conducted through video conferencing is there. Similar requirements are to be fulfilled, but now only the platform is changed. There we are doing it physically. Now we are to comply the same protocol. We are to follow the same protocol for the purpose of recording the evidence through video conferencing. Now, after establishing the identity of the witness or the required person, as the case may be, at the remote point, and also after supplying the copy of the proof of identity of the witness, the next step would be that at the scheduled time, it is the coordinator at the court point who shall connect the remote user to the court. It would be the coordinator at the court point who shall connect the remote user to the court, which is evident from Rule 10.6. Now, let us see how the witness is to be examined. So now I have divided the entire procedure in two parts. One is preliminary stages and another is recording of the evidence. What precautions or what steps are involved in that? So in the preparatory stage, as per Rule 14.3, once the proceedings have commenced, no person will be permitted to participate in the virtual hearing save and except with the permission of the court. Rule 8.1 says that the coordinator at the remote point shall ensure that no person is present at a remote point save and except the person being examined and those whose presence deemed administratively necessary by the coordinator for the proceeding to continue. Rule 14.6 speaks that the establishment and disconnection of the links would be regulated by the orders of the court. Rule 14.4 says that the participant after joining the hearing remain in the virtual lobby if available until they are admitted to virtual hearing by the coordinator at the court point. Participation in the proceeding shall constitute consent by the participants to the proceeding being conducted by video conferencing as per Rule 14.5. The examination shall, as far as practicable, proceed without interruption or grant the unnecessary adjournments. However, the court or the commissioner, as the case may be, will be at the liberty to determine whether an adjournment should be granted and if so, on what terms as per Rule 8.13. The court shall be guided by the provisions of CPC, Chapter 23, Part B, CRPC, and the Evidence Act, IT Act, while examining the person through video conferencing as per Rule 8.14. Where the documents are to be relied upon by the party during the examination of the witness, before the examination of the witness, the documents, if any, sought to be relied upon shall be transmitted by the applicant to the witness so that the witness acquires familiarity with the said document. The applicant will file an acknowledgement with the court in this behalf under Rule 8.4. Now, subject to the orders as the court may pass, in case any party or person authorized by court is desirous to be physically present at the remote point at the time of recording of the testimony, such party shall make its own arrangement for appearance or representation at the remote point under Rule 8.16. That apart, the court may also impose such other conditions as are necessary in a given set of facts for effective recording of examination under Rule 8.12. Now, after the completion of those preliminary stages, now comes the stage of recording of the evidence. Now, as in the physical court, once we establish the identity of the witness or the required person, we administer oath to that person. Now, in accordance with that procedure only, under Rule 8.2, it is stated that as in the physical recording of the evidence before the court, the oath will be administered to the person who is being examined by the coordinator at the court point, and the examination of the witness shall begin. As we do in the physical recording of the evidence, the court would be at the liberty to record the demeanor of the person to be examined under Rule 8.6. The court will also note the objections raised during the deposition of the person being examined and rule on them under Rule 8.7. Now, during the course of examination, it is the duty of the coordinator at the remote point to ensure that no unauthorized recording device is used as per Rule 5.6.2. No authorized person enters the video conferencing room when the video conferencing is in progress under Rule 5.6.3. The person being examined at the remote point is not prompted, tutored, coaxed, induced, or coerced in any manner by any person, and that person being examined does not refer to any document, script, or device without the permission of the concerned court during the course of examination under Rule 5.6.4. Further, the court shall satisfy that the advocate, required person, or any other participant that the court may deem necessary at the remote point or the court point can be seen, heard clearly, and can clearly see and hear the court as per Rule 14.7. To ensure that the video conferencing is conducted seamlessly, the difficulties, if any, experience in any must be brought to the notice of the court at the earliest on the official email address and mobile of the court point coordinator, which has been furnished to the participant before the commencement of the virtual hearing. No complaint shall subsequently be entertained as per Rule 14.8. Now, during the course of examination of the witness, if a person is examined with a reference to a particular document, for example, a medical doctor, then as the witness has already received a duly certified photocopy of that document, like medical documents with the summons, as I have already referred above, at the time of the exhibition of the document, the original document should be exhibited at the court point with the deposition of the concerned person be examined. So the witness who is present at the remote point, since he has already received the document, the exhibition of the document already been received by the remote user will be shown and exhibited at the court point and not at the remote point. Now the question arises as to how the documents at the remote point are to be exhibited or shown to the witness or accused. Now Rule 9 speaks that if the document is at the remote point, by transmitting the copy of image of the document to the remote point electronically, including through a document visualizer, if the document at the remote point, by putting it through the person or transmitting the same to the court point electronically through a document visualizer, the hard copy of the document countersigned by the witness and the coordinator at the remote point shall be dispatched thereafter to the court point by authorized courier or registered speed post or any other authorized means such as special messenger. Now, what will happen on the completion of the examination of the witness? Now, after the examination of the witness, as we also do in the physical court, we obtain the signature of the witness. But now, since the evidence is being recorded at the remote point, how the signature of the witness present at remote point is to be procured. Now, for that, I would like to draw your attention to Rule 8. It says that after examination of the witness, the court shall obtain the signature of the person being examined. The signed transcript will form part of the record of the judicial proceedings. The signature on the transcript of the person be examined shall be obtained in either of the following manner. The first manner would be that if the digital signatures are available at both the concerned court point and the remote point, the soft copy of the transcript digitally signed by the presiding judge at the court point shall be sent by the official email to the remote point, where a printout of the same will be taken and signed by the person being examined. A scanned copy of the transcript digitally signed by the coordinator at the remote point would be transmitted by official email of the court point. The hard copy of the signed transcript will be dispatched after the testimony is over, preferably within 3 days by the coordinator at the remote point to the court point by recognized courier or registered post. Now, this was a scenario when the digital signatures were available. Now, what if the digital signatures are not available? In that situation, the printout of the transcript shall be signed by the presiding judge and the representative of the parties, if any, at the court point, and it shall be sent in non-editable scanned format to the official email of the remote point, where a printout of the same will be taken and signed by the person examined and countersigned by the coordinator at the remote point. A non-editable scanned format of the transcript so signed shall be sent by the coordinator of the remote point to the official email account of the court point, where the printout of the same will be taken and shall be made a part of the judicial record. The hard copy will also be dispatched preferably within 3 days by the coordinator at the remote point to the court point by recognized courier or registered post. Now, what is the duty of the court after the completion of the evidence through video conferencing is given under Rule 10. It says that on completion of video conferencing proceeding, the court shall mention in the order sheet the time and duration of the proceedings, the software used in case the software used is not the designated video conferencing software, the issues on which the court was addressed, and the documents, if any, that were produced and transmitted online. In case a digital recording is tendered, the court shall record its duration in the order sheet along with other requisite details. The court shall also record satisfaction as to the clarity, sound, and connectivity for both court users and remote users as per Rule 10.8. On completion of the video conferencing, if a remote user is of the opinion that they were prejudiced due to poor video or audio quality, the remote user shall immediately inform the coordinator at the court point, who shall in turn communicate this information to the court without any delay. The court shall consider hearing to be incomplete and the parties may be asked to reconnect or make a physical appearance under Rule 10.9. Now, wherever any proceeding is carried out by the court under these rules by taking recourse to video conferencing, this shall be specifically mentioned in the order sheet under Rule 14.9. Now, how the recorded video is to be preserved and what about its encryption? Rule 8.9 speaks that an audio-visual recording of the examination of the person shall be preserved and the encrypted master copy with hash value shall be retained as a part of the record. Now, this is the entire procedure with regard to the conducting of the proceeding through video conferencing. That apart, we have certain questions which are related to the proceedings conducted through video conferencing. One of the questions is that where accused is in custody and is not present at the court point, how the video conferencing of the accused for examination of the witness be conducted. For example, the accused is at jail, the witness is at the remote point, and there is a court point also. In that scenario, how the evidence or how the proceeding is to be conducted. Now, answer to this query is given under Rule 12.8 and Rule 8.3. It says that if the accused is in custody and not present at the court point, the court will order a multi-point video conferencing between itself, the witness, and the accused in custody to facilitate recording of the statement of the witness, including medical or other expert. The court shall ensure that the defense of the accused is not prejudiced in any manner and that the safeguards contained in Rule 8.3 are observed. Under Rule 8.3, when the person being examined or the accused to be tried is in custody, the statement or as the case may be, the testimony may be recorded through video conferencing. The court shall provide opportunity to the under trial prisoner to consult in privacy with their counsel before during or after the video conferencing. Now, another question is that how the video conferencing is to be convened for making oral submissions or arguments. For that, attention is drawn to Rule 6.5 that says that in case the video conferencing event is convened for making oral submissions, the order may require the advocate or party in person to submit written arguments and precedents, if any, in advance on the official email ID of the concerned court. Now, what is the procedure to be adopted for the purpose of judicial remand, framing of charge, examination of accused, and proceeding under section 164 CRPC? For that, I would like to draw the attention of the esteemed audience to Rule 11.1. It says that the court may, at its discretion, authorize detention of an accused, frame charge in a criminal trial under CRPC by video conferencing. However, ordinarily, judicial remand in the first instance or police remand shall not be granted through video conferencing, save and except in exceptional circumstances for reasons to be recorded in writing. Now, the term exceptional circumstances is given under Rule 2.8, which says that exceptional circumstances include illustratively a pandemic, natural calamities, circumstances implicating law and order, and matters relating to the safety of the accused and witnesses. So ordinarily, the first remand or the police remand is not to be given through video conferencing unless there are exceptional circumstances prevailing. Now, the court may, in exceptional circumstances for reasons to be recorded in writing, examine a witness or an accused under section 164 CRPC, or record the statement of the accused under section 313 CRPC through video conferencing while observing all precautions to ensure that the witness or the accused, as the case may be, is free of any form of coercion, threat, or undue influence. The court shall ensure compliance with section 26 of the Evidence Act as per Rule 11.2. Another question is that whether video conferencing can be conducted for camps, lok adalat, jail lok adalat, whether the facility is available to legal aid clinics, what would be the legality of the award passed by way of video conferencing in lok adalat. Now, according to Rule 15.1, in conformity with the provisions of Legal Services Authority Act and the laws in force in proceedings related to legal aid clinics, camps, lok adalat, or jail lok adalat, any person who at the remote point is in jail or prison shall be examined by the chairman or secretary of the district Legal Service Authority or Taluka Legal Service Committee, or with members of Lok Adalat before passing any award or orders in accordance with law. Such award or order shall have the same force as if it was passed by the regular Lok Adalat or jail Lok Adalat under Rule 15.2. Copy of the award or order and the record of the proceedings shall be sent to the remote point under Rule 15.3. Now, there is a provision in the rules also with regard to view the proceedings live, view the video conferencing proceedings live. So the question is that whether the persons who are not parties to the case can be allowed to view the proceedings. Now, according to Rule 16.1, in order to observe the requirement of an open court proceedings, member of the public will be allowed to view court hearings conducted through video conferencing except proceeding ordered for persons recorded in writing to be conducted in camera. The court shall endeavor to make available sufficient links consistent with the available bandwidth for accessing the proceedings. Where for any reason a person unconnected with the case is present at the remote point, that person shall be identified by the coordinator at the remote point at the start of the proceeding, and the purpose of the presence of that person shall be conveyed to the court. Such a person shall continue to remain present only if so ordered by the court under Rule 16.2. Now that apart, we have three more rules. Rule 17 speaks with regard to the reference to words and expressions, that words and expressions used and not defined in these rules shall have the same meaning as assigned to them in the CPC, CRPC, Evidence Act, IT Act, and the General Clauses Act. Rule 18 speaks with regard to the power to relax, that the High Court may, if satisfied that the operation of any rule is causing undue hardship, by an order dispense with or relax the requirement of that rule to such extent and subject to such conditions or as may be stipulated to deal with the case in just and equitable manner. And Rule 19 gives the residual provisions, that matters with respect to which no express provision has been made in these rules shall be decided by the court consistent with the principle of furthering the interest of justice. So with the limited understanding that I could gather with regard to the said rules, I have tried to make our esteemed audience apprised of all the provisions as laid down under the rules in the new video conferencing rules. And I do understand that the implementation of this new technology, if we forget as to what and how we are conducting the video conferencing otherwise, and other technical issues that we are facing, or the administrative lack of administrative infrastructure that we are having, we have to understand and we have to keep this in mind, that any implementation of new technology will have its own hiccups. It will have its initial hiccups, and these hiccups are to be removed by proper application of law with sufficient safeguards. If we use these rules, if we use and implement these rules for the proceedings before the court as so allowed, then more and more issues will crop up, and it will be easier for the higher authorities to find the solution for the same, so that the idea that the proceedings of a case can be conducted through video conferencing at a remote point without visiting the court can be achieved. So that's all with my presentation with regard to the video conferencing rules. Thank you very much for giving me such a patient hearing. And as I can see that there's a lot of interaction going on our YouTube channel. Lots of chats are there with regard to the video conferencing rules. I shall not be in the position to answer any of those questions, because then I have to see those questions, and maybe I am also not ready with the answers because it would include the practical application. But I assure you that I'll go through those questions, and to my limited understanding or to my knowledge, I would be able to cater those answers to those questions. This video, I hope, would be very useful to the audience and all the judicial officers. And this video is will be available on our YouTube channel. So as and when any issue crops up with regard to the video conferencing rules, you can always refer to this video. Apart from that, we are also going to share a feedback form with all our esteemed audience with regard to this webinar. We shall be sending you the link. So it is requested that you all fill that feedback form with regard to this webinar, particularly the rules, particularly the video conferencing rules. With that note, again, I thank you very much for being here, and till the time we meet again, namaskar.